Welcome to the podcast, Let's Talk PWS, a series all about Prader-Willi syndrome. I'm Susie.
And I'm Katie. Let's start talking.
Welcome to episode 17. I'm excited about this one. I love it when we get a viewer's choice question coming in to us on Let's Talk PWS. And today we've got the complex topic about guardianship, wills and disability trusts with special guest Clint.
Yes, so it was Debbie who sent in the question, and her question was, "Hi Katie, I love the podcast. It's so great. Thanks, Debbie. I have been chatting recently with the other mums about wills and setting up trusts for our kids, and we're all so clueless. Would love to hear more from you, more experienced mums on this." And so we didn't have very much experience, but then we thought we'll better get an expert. And Debbie said that there's a lawyer up in Brisbane who has a child with Prader-Willi syndrome, and so we better call Clint. So Clint Kanther is a lawyer practicing in the areas of building and construction, litigation, commercial and personal injury law. His team at Kanther Law support their clients by providing succinct advice with clear recommendations. He has a broad range of experience across the transport and logistics, construction and mining and manufacturing sectors. Thanks for joining us today, Clint.
Thanks for having me on. The thing perhaps missing from my resume in there is, and certainly in the last sort of 10 years I've moved into, I have a wills and estate practice as well as estate planning, estate litigation, which is certainly what we're talking about today. So as time's gone on, my appetite for getting into scraps with builders has become less, and I'd rather deal in spaces which are a little bit less stressful.
Brilliant.
I can appreciate that. And I just wanted to add, Katie, I've actually just gone through this whole rigmarole, and I know you're obviously very passionate about it, Clint, but I've gone through the whole rigmarole again of setting up our estate and wills and testamentary trusts and all the rest of it, and the special disability trust. Do I understand it? Not really. The lawyer did say she'll come and dumb it down for me, which I'm still waiting for that to happen, but I will follow up with her about that. But when did you realise that you needed a legal plan for your child's future?
Look, when we found out we were pregnant, and that's certainly one of those triggers of times to make sure that you update your will. Mm-hmm. If you do your estate planning properly, and there's two parts to planning. There's planning for whilst you're alive, and then there's planning for after you die. Mm-hmm. And certainly, if you do it right, you should only have to do it or change it when there's certain events, such as you marry or remarry or divorce, or if you have kids. Sometimes if you come into a significant amount of property or inherit a great lot of wealth, you may need to change the way you're structured. But if you've done it right, you shouldn't have to change your will or update your will every couple of years. It's only on those sort of particular events. So a lot of people, they do their will once. If they do it properly, they'll never see it again. It'll be a matter for their executor. Unless things change.
That is a lesson I have learned, and I'm clear on that now. So I do say that to a lot of the Prader families that I do speak to about having your affairs in order.
Yes.
Because our daughters are in their 20s now, and we won't declare how old we are, but anything can happen at any time, and I just want to make sure that don't have to worry about extra complications like sorting out wills. Let's pivot to talking about parents, and I come across this a lot in the lion world with restricted practices and so forth, but guardianship for someone with Prader-Willi syndrome and disability trusts. Many people are quite perplexed about how all that works and where to even begin. Can you explain how these pieces fit together within Australia? And then, of course, there's the different jurisdictions between the different states as well, which do my head in.
Certainly the different jurisdictions and the different things between the states, a lot of that's got to do with dealing with guardianship, particularly when there's issues over guardianship and you're having to resolve those, because they are resolved within the state courts for the most part. For example, in Queensland, there's the Guardianship and Administrative Tribunal, which is administered through what we call QCAT, and each state will have its sort of equivalent sort of thereof. But this is why the whole issue of guardianship in particular, a lot of people think about their wills. People with kids will often think about, who's going to look after them when the kids are older. But this is where kids with special needs families, parents with kids that are unlikely to live independently or may need assistance in the future, they need to be thinking about those things early. It's not just about who's going to break up and sell all my stuff and give it away. It's who's going to look after my child and who's going to administer trusts, who's going to make sure is going to provide the best care for them. And if need be, having alternatives in place to ensure and having those discussions early with those people that may take on that role. It's a very difficult conversation that you've got to have because you're talking about, for the most part, you're talking about what happens if I lose capacity or when I die, which is inevitable. And there is a lot of parents, and often there's some that I'm dealing with that are in their 70s and 80s, and some that I've dealt with that do have special needs families that stick their head in the sand for so long. And it's much harder to make those administrative arrangements, particularly when you're dealing with people that are starting to get older and may not have capacity themselves or having their own problems. So the best thing you can do is have a plan as soon as you start talking about it now, talking about it with your partner, talking about it with your family, talking about it with your friends. Because if we can document it now when we've got time to think it through and supply all that information, it's like packing a grab bag in case something bad happens. You're doing that so there's less administration for the people that you leave behind to tromp through to look after your kids, and particularly the ones that don't have that capacity to look after themselves.
So just distinguishing wills and estates versus QCAT or NCAT, VCAT, whichever state you reside in. So get your wills. What I'm hearing is then get your wills and estate affairs mapped out, documented and executed earlier on as soon as you can, because there's also a cost involved, right?
Yes.
And then the QCAT stuff with a Prader-Willi syndrome person, generally when they're under 18, it's informal consent for your restricted practices for food and stuff like that, restricting access to food. But then when they turn 18, then what?
So look, when they take a person who doesn't have legal capacity, who's an adult, there is an office of adult guardians. They are treated as similar to the way that a child under the age of 18. There are orders that can be put in place for those people that don't have capacity. This is where, if you have clear provisions in your will and you have set yourself up properly, getting orders to become somebody's legal guardian in circumstances where you're not the next of kin or a parent is much easier. But often one of the complications that we also have, we might perhaps touch on this later, I'm not a family lawyer, but where you have shared responsibility upon separated parents, they may have differing wills about who takes over as the guardian. And this is where all of these early conversations are so important to avoid the disputes once someone passes away. So that a lot of that guardian VCAT stuff is that if we're just getting someone appointed as a legal guardian, if someone is appointed under somebody's will, so for example, the will expresses a very clear intention as to who is to be the guardian of somebody's child or person with disability, it makes their life so much easier, as opposed to if it's silent on the matter and you then need to go and gather evidence to obtain that appointment through VCAT or QCAT or through those administrative tribunals. And so that's what I'm talking about, having the conversations early and then going to see a lawyer and getting it documented. If you do that, it smooths the process considerably, particularly if you start to add complicating issues on, such as families with separated parents, often families where we're dealing with elderly parents or where there's no siblings and those sorts of things, and there may not be a clear next of kin.
Complex, isn't it? If we're speaking to parents who have got a child with a disability and they haven't got any planning yet, what are the first three things that you'd be saying to them?
The first thing is that I try to get to people is to say, what do you want done with your stuff? And put it in simple terms, document it, write it down in an email and say, this is what I want to happen with my things. Often when we've got families with special needs, for the most part, the lion's share of that is going to the child who needs it the most. And for the most part, that's the sort of starting point, is that if there is families that do have kids with more than one child with special needs, and they need to sort of take that into consideration. And there is also then blended families where we're talking about kids with special needs that are that have different fathers or different mothers and those sorts of things, and what's happening with those sort of. So it's about understanding what you want done and what your intention is to, and sort of have that clear first. That's the first thing. The second thing is who's going to look after your estate. It should be someone that you trust, but it also needs to be someone with the capability to do it. And you can plan for the future in that regard. A lot of people will nominate children to become their executor, even though they are still only 17 or 18 at the time. But what they can do is there's measures you can put in place by appointing joint executors that will act together, and you can appoint someone younger with someone with a little bit more intelligence or a little bit more experience in life to be able to make sometimes difficult decisions that need to occur. But the main thing is having an idea of who you are going to trust to attend to the administration. I try to discourage clients from appointing myself as a lawyer or appointing a solicitor. Solicitors will include charging clauses in their wills. And the last thing is the estate needs is to, some lawyers will quite happily appoint themselves as an executor and do it at no cost. But the standard practice is usually, I find, when a lawyer is appointed, they will charge for their services as an executor. In some states, there's a lot of clear requirements behind it, but trying to appoint it, and ideally trying to appoint someone who is known to the family and known to all parties concerned. When you appoint outsiders and people that aren't necessarily known by all family members, because you think they're perhaps the best person to deal with it, because they might have an accounting background or some sort of professional background. I mean, it's not always the right person. The right person is the person you trust the most to have your interests at heart and make sure what's in your will is done that way. They can get the necessary advice they need to give effect to that by going and getting good legal representation. So you don't have to necessarily point the smartest person in the room. And all the other thing is part of that is that of finding that person you want to manage your affairs is to make sure you've got backups. A lot of people just go, they'll sort it out if that person either dies before me. But this is about only having to draft your will once, is by making sure you've got an alternative appointed. So, my wife will be the executor in the first instance. And if that's not the case, it might be a brother or a sister or an auntie or aunt. And then you can then have, as the ultimate backup, it can be a lawyer or the law firm that's you're giving instructions to prepare it. So look, they're the first two things. Then they are the key elements of any will. What do I want done with my stuff and who's going to look after it?
If you don't have a will, we know it goes to probate, but could you walk us through what that looks like? I mean, I heard it's completely messy.
It's just the rules. There are some nuances from state to state.
Yeah.
There is effectively legislation in each state that deals with what happens if somebody doesn't have a will. And so someone will have to apply for letters of administration, which means they'll have to say, this is why I'm the best person to administer the estate. And then the distributions under that estate are dealt with according to those rules.
And how long does that all take? Because it's the last thing you want to be dealing with.
It also can take a bit longer and cost a bit more. And the same is to be said about an improperly executed will. When you're trying to get probate or on what they call an informal will or something that's not done in accordance with the regulations. And in that, I'll throw this out there right now. A DIY will kit is a wonderfully cheap alternative to engaging a solicitor, but can be far more expensive in the long run. If you need to get something in place and you need it done quickly, I wouldn't say to people don't use them at all, but I would use them as an interim measure before going to get some proper legal advice. Often, DIY kits are usually a lot of the reason why I get referred to work dealing with estate disputes, because it won't necessarily take into account everything you need. If you're talking about families with special needs, it's all the more important to go and get legal advice to make sure that your will is properly set up and not just that, complies with the regulations, is properly executed and then properly stored so it doesn't go missing. Often a will is something you set up and then you don't need it for 30 years. Most lawyers, firms like myself, we have a safe full of wills, and so when people go looking or advertise and they need to go looking for it, as long as the executor's we usually provide them with a copy, but we retain all of the originals because even that's another problem itself if you don't have the original will. So look, that's sort of some of the background. So DIY kits, sure, as a stopgap if you need them, but I don't recommend them as your sort of permanent solution, because it won't necessarily get you where you need to go, and the cost that will then come to your estate can be considerable in fixing problems with DIY wills.
And what are the two types of guardianship, and how does that all work?
So when it comes to guardianship, there's two parts to it. There's a financial element to it, and then there is the sort of everything else. So one's called a guardian and one will be an administrator. The administrator deals with financial affairs, and they won't necessarily be the same person. And often when there's disputes, you find the first thing that gets taken away are administrative powers. Because administrators is the responsibility for administering or managing someone's financial affairs, which can include property and those sorts of things. The guardianship aspect is talking about decisions about medical treatment, where somebody lives, what they can do and can't do, what colour hat they wear when they go out, that sort of everything else factor. And they can sometimes be two separate people, and you can, in your will, appoint or have two different people appointed for such purposes. You can appoint someone as the guardian to deal with somebody's day-to-day needs, someone that will live with them and decide where they live, and another person that then manages the finances. It is quite common that we see that sort of separation of responsibility, and that comes both with a separation when it comes to appointing people as well, and also when we're talking about power of attorney and those sorts of things, which can be appointed when someone's there to make decisions for other people.
I mean, everyone's circumstances are very different, but it sounds costly.
It sounds like there's all these considerations and can costly. Simple wills can be, and when I say simple ones, which sort of often where we sort of have a mutual will arrangement, or there's not, we're not talking about blended families and those sorts of things. Some firms may only charge, $500 or $600 for a very simple will, and that usually will come with a power of attorney and those sorts of things. But what that won't provide for is things as such as setting up trusts or complicated guardianship matters. And often in terms of the estate itself, what you spend on your will is, in many cases, proportionate to the size of the estate you're dealing with. When I'm dealing with estates that are worth millions of dollars, there's complex companies involved, and often with the size of an estate comes the complexities of the structures. If we're talking about people that have the primary asset is often the family home, and if that's the case, there's the family home, some superannuation policies that we might touch on that separately about nominated beneficiaries and the like. But there's a family home, some super policies, and some cash at the bank. They're the sorts of cases where a will should not cost more than, at worst, sort of $1,500 if we've got a few extra bits and pieces in there. Shop around if you're not sure. I mean, ideally, I encourage people to go through a lawyer they trust or someone who they can be referred through the family who they know. It's often, if it's done properly, it should be quite a personal experience. The lawyer should, it's not just a case of send me an email with what you want and I'll send you out a will and then we'll get it executed. The lawyer should sit with you, go through. You should have a very good understanding in simple terms as to what's happening with my things and who's going to look after it. And there should be, and the will is an opportunity for people to put in those other personal information in there as well. I said it can be done without much cost to get something simple in place. If you have the privilege and the benefit of having more assets and the like at your disposal, sure, you're going to have to spend more to have them properly appointed, because we're dealing with handing over companies and the like, and as well as there's other structuring that might be done during your lifetime to set things up. So things such as special disability trusts and those sorts of things, which can be set up during the lifetime of an individual as opposed to a simple will. If you're going to a lawyer with a simple will and they're sort of saying, it's going to cost $5,000, I would suggest you shop around.
And disability trusts, what are they and how does that all come together?
So a disability trust, and I have to do the lawyer thing and put a rider on this. I can't give you financial advice about a disability trust. A special disability trust has a significant amount of financial benefits, because if it's the way it's structured, it can be set up in a way where it is a disability trust is designed for a single person. So you set it up for somebody who will have to qualify due to their condition or their disability to be able to be entitled to the trust, and they will be a single beneficiary. And the funds or the proceeds for that trust are effectively for their care or for their sort of use and enjoyment. So the benefit of setting it up is what it does is you can effectively cut aside a significant amount of funding. Anyone can contribute to that as well. So if you've got friends and family, some of them, if they set a special disability trust up, often you'll find family members will contribute to that trust in their wills as well, which you can provide for. They can do that. And what that does is that it won't necessarily impact on that person's other benefits. So they get benefits under Centrelink, as well as some other sort of government payments and the like. Payments that are made from the disability trust usually won't affect those benefits until they go over a particular threshold. And so structuring one of those, and that the trust can hold, I think it's about $1 million sort of worth of assets these days, without then impacting on those things as well. So you can put assets in the name of a special disability trust that can be income generating assets that you can use for the care of that person in the future. And these are the sorts of things you can set up in the course of somebody's lifetime. I mean, there is then just straight family trust that can be set up. Often you'll find that families, and this avoids a dispute under a will, if you set up things or structures such as trusts and companies and the like, and other sort of legal structures, and this is where it can get quite costly. About this sort of stuff. You can set this stuff up in somebody's lifetime for their benefit, and it avoids them being attacked under a will, because any will can be subject to a family provision application or somebody seeking to claim on the will in terms of the way it's, just because that's what you wanted, can come and apply under it, particularly if they say that they have a need or an entitlement as one of the beneficiaries. Families with 6 brothers and sisters, none of which like each other, if they didn't get their fair share of the will, they can bring an application. And unfortunately, even though those applications might sometimes be unmeritorious, for the most part, the legal costs come out of those applications. And what you can see is a significant chunk of the estate then going to legal fees in dealing with disputes. That's why we encourage people to get some proper legal advice, properly set up wills to take into account these sorts of issues that might come out of the woodwork. Possible for assets and things like that to pass without necessarily going through the estate. And that's where you can set it up by appointing people as joint tenants under properties, or things like superannuation, making sure your superannuation has a nominated beneficiary.
Oh, it's a lot to consider there, isn't it? And I guess I've heard quite a few times that if you don't have your affairs in order and someone passes away, it brings out the worst in the family sometimes.
That is an understatement. Money, I've watched even families with relatively small estates. You watch brothers and sisters that go into this, that a parent or a loved one's passed away, then just destroy the rest of the family. And this is all about early communication. Communicate with who's getting what. Don't leave it as a surprise.
I completely agree with you, Clint. So the key message being, get your affairs in order.
Yes, earlier the better.
All right.
Fantastic.
Okay. Well, thank you very much for that insight. It's very complex, and I'm sure everyone's circumstances are different. They'll need to go and seek their own legal advice.
Yeah.
Are you open for a flood of Prada Willie families coming to you?
I'm more than happy to talk to Prada Willie families. Certainly for Prada Willie families, if it's just some guidance that they need or they are after something set up, most of those Prada Willie families will know how to get in touch with me. And I said it should cost nothing to have a brief initial consultation with a lawyer.
Correct.
And so if there are Prada Willie families out there that don't want to have to explain the whole backstory to their child's condition and want to talk to someone, they're more than willing to get in touch with my firm. I'm the only person practicing law with my surname in Australia, so I'm not that difficult to find. They're more than welcome to reach out, and if I can assist, I will.
Great.
Thank you. And we'll
Thank
put
you
all of
so
your,
much.
Yeah, we'll put Clint's details in the chat. And yes, thank you very much for joining us and for this very interesting conversation, but very important conversation.
Not a problem, anytime.
Thank you. As we close tonight, don't forget to sign up as members at pws.org.au, where you'll also find ways to donate and sponsor our various projects and initiatives. Please remember to like, follow and share us on our socials. And until next week, let's keep talking.